Thank you, everyone. And it just so happens that today, January 28th, is Global Data Privacy Day. So happy Data Privacy Day, everybody. I think our topic today is very timely, very relevant, particularly to in-house counsel that are impacted by these regulations. Before we dive in, I wanted to give you just a really quick background on Exterro, if you're not familiar with Exterro. Really, for the last 15 years, Exterro has been the leader in e-discovery software, really managing the litigation lifecycle from a legal hold to search, collection, review, redaction, and ultimate production. Now, they did acquire Jordan Lawrence, which I come from Jordan Lawrence for over 25 years. They acquired Jordan Lawrence about a year and a half ago. And so, really to round out their offering, because what we're seeing is this convergence between data privacy, cybersecurity, and e-discovery. We work with over 500 global clients, and just want to point out, particularly for the audience today, that the Association of Corporate Counsel has selected Exterro as their exclusive alliance partner for cybersecurity, privacy, and e-discovery compliance. We're also well recognized in the IT space, with Gartner naming us a cool vendor for our data inventory solution back in 2011, and again last year. So enough about Exterro. Let's get to just some real quick introductions here. And, I've had the pleasure of speaking to several ACC chapters. It's been a while since I've talked to ACC San Francisco, so very happy to be back, if you will. I wish it was in person, but I'll take virtual. I'm the Director of Strategic Partnerships at Exterro. I've been with the organization over 25 years in a myriad of roles. I've been in the trenches with our clients as they've tackled these really complex data governance issues, and really excited to be here with my co-panelists. And you can't have data privacy without data security. So I'm very excited to have Fotis join us. Fotis, can you give us a little bit of background on yourself?
Yeah, thanks so much, Rebecca, and thanks for everyone for attending the meeting. Like you can see on my virtual background, I used to live in San Francisco. I love the Golden Gate, so that's what I chose as my background. I came to Stout. So Stout, I lead the digital and AI practice. Stout is a global investment firm, and we also provide consulting services. I'm under this management consulting umbrella, providing primarily business intelligence, data analytics, and also cybersecurity services. I do come from a heavy consulting background, working for McKinsey in the past and also Accenture on the digital domain. We have a partnership with Rebecca. We're trying to be cool as well. So, being one of the coolest companies in Gartner, we're using for our cybersecurity assessments, for data inventory, data retention. I collaborate heavily with general counsels, chief security officers, and chief information officers. And I think we'll give you a great review about the latest and greatest when it comes down to legal frameworks and the IT angle behind them.
Great. And Devika, very excited for you to join our panel today as well. Can you give us a little bit of background?
Sure. So I'm Devika Hornbacher. I am a partner with Vincent & Elkins. I've been practicing for about 14 years, and I actually split time with New York. So I'm in Houston right now, split time with New York, but the pandemic has made me Houston only. And I lead our cybersecurity and data privacy practice, as well as our technology transactions team. So I think that's one of the unique things about what V&E does is, and what we want to talk about in this presentation I'm excited about, is kind of the convergence between doing a transaction, having a contract, and then the data privacy implications of that. So in addition to helping clients stand up data privacy programs from jump, having talked to Rebecca and working with Jordan Lawrence, right, kind of do the data and inventory from scratch, we also do the next step with the third parties and trying to follow the entire data lifecycle. So excited to be a part of the program.
Thank you so much. So I think we could probably spend all day on this topic. So we really had to kind of narrow in on what we were going to cover. And what we wanted to kind of break this into two parts. One is sort of the shifting regulatory landscape. So we'll touch on some of the things that are making headlines today when it comes to the regulations. And then we're going to shift into, so how do you tackle this, right? How do you streamline compliance, operationalize this in a way that is sort of nimble, right, as new regulations come online? And we are going to incorporate some polls today, which I think is great. I love audience participation. And obviously, there's a lot of regulations that are out there, right? And we're going to touch on some of these today. But I'd like to have our first poll. And so, Carrie, thank you for bringing that up. We'd like to just hear from the audience to see what your biggest concern is when it comes to these regulations. And this is not an exhaustive list. Obviously, there are other regulations that are not listed here, but these are the ones that I think that are kind of in the headlines recently. So we'll give folks a little bit of time to respond. Looks like we're at about 55% of folks responding to that. All of the above. I think that's winning at the moment. All right, so it looks like we have concerns across the board, and I think that's wise for companies to really not focus in on one particular regulation, because there's going to be more on the horizon. And I think, as you'll see as we go through the discussion today, that building a data privacy, data protection program, you have to incorporate the nuances of the various laws, but you have to have a solid foundation so that your program can be agile and adjust with things like Schrems 2 and CPRA. All right. So we'll go ahead and continue moving on. I'm going to go ahead and close the poll here. All right. So Devika, can you kind of jump in and kind of talk to us about what's happening with the regulations today?
Sure, and I want to highlight, this slide, as Rebecca said, kind of puts the big headers, but it's everywhere. And I think one of the things we wanted to talk about is that trying to keep up with it, right? So you've got a situation where if you're an organization, suppose you're an organization in Texas. So you see Texas is not a flag that's shown on here, but yet you have a situation where CCPA and CPRA could apply to you if you meet the thresholds under the current CCPA, which is 25 million in annual gross revenues, 50,000 information from 50,000 consumers, household devices, or over half your business is basically derived from selling or sharing data, or selling now to be sharing when it comes to CPRA. And so you got that, and then, oh wait, you've got the New York Shield Act going to FOTUS and kind of the cyber side of it. And then, oh yeah, of course you're in North America, so you got to deal with PIPEDA and now their mandatory breach notification rule that was passed a couple of years ago. And then, oh, well, we're expanding into Latin America. Great. Well, Brazil's got its own version of GDPR, which people thought was not going to be enforced. I will tell you. So like, there's no way Brazil has an infrastructure to enforce this. And boom, August 2020, here we go, right? It is enacted and it is enforced. And don't forget, we all deal with customers in Europe. And so you got this Texas company, for example, who maybe markets to Europe because they want to expand their business, but they don't have any presence there. But they've got this law now that applies to that data. And I think that's one of the kind of the overlays, and not even not even getting into Australia, Japan, like all the others that are out there. Taiwan, when people say they have business in Asia, I say, okay, we should talk, right? Because there's a slew. And so one of the questions I often get from a legal perspective when we help with these programs is, well, Devika, what am I supposed to do? There's no way I can comply with all this and still get with the budget I have. And what we usually say is it's really looking at each of the regulations and deciding from a risk perspective what's most important for your organization. Because if you try to do I've had people who say, well, I'm going to do the strictest. And no offense to Paula and the privacy professionals who, that's what they do all the time. But I think Paula would agree. It's not do the strictest because you're going to run out of money. And you're still, perfect compliance, I always say, is a fallacy. It's an oxymoron. So it's about looking at the sum total of the risk and deciding, okay, you know what, this is where I'm most at risk, not just from regulators, but also from consumers complaining about or feeling like I'm not caring about their privacy. And so then you decide to shape your program around that. So Rebecca, I could go deeper into each of the ones and CPRA, but I kind of want to give that overview of that's where we are with the data privacy regulations and how we're helping folks comply with them.
Yeah. Well, let's kind of take a look here. We have some slides on CCPA, and I think, the audience is probably fairly familiar with this. It is sort of a pioneering law. California was the first to have a data breach law, and they're doing it again with data privacy regulations. And so it went into effect in January 1st, 2020. Enforcement began July 1st, 2020. Devika, can you talk a little bit about kind of where things stand? There's also, I think I want to mention, there's been a lot of litigation
Right. Yeah, IAPP had done a little chart. It's hard to track this when it comes to litigation about CCPA because as those who practice know, and some of the other may have heard, the private right of action is actually narrow. It's scary. Don't get me wrong, a private right of action under CCPA is scary, but it's narrow. It's only for data breaches that resulted from a failure to have reasonable security measures. So that's a liability and a risk, but not as huge. But you still have, I will tell you, folks filing litigation and citing CCPA in the complaints. And that's been, IAP has tracked some of that. One of the things, though, I will tell you, the AG's office has been focusing on, and if you and is kind of publicized, is they're taking easy pickings, Rebecca, right now. So they're saying, I'm going to look at your privacy notice. Maybe I can't get into what's going on behind the scenes and make a determination on whether or not you sell personal information, which is one of the big things that CCPA has that's totally different from GDPR and other privacy regulations. But what I can do is look at your privacy notice and see if you got the right disclosures up front. And some of the enforcement actions have been interesting in that at least one of the enforcement actions that I've talked to one of my consultants about was because it did not expressly say you do not sell. It was silent on that part. And so that kind of thing is having an enforcement action coming after it. So just want to highlight that enforcement is real, that it's out there, that notice right now is what's on the AG's mind just because it's the easy thing to look at. But all the experts say that eventually it will shift to that opt-out and whether or not that opt-out right is being complied with in a quick manner and in a complete manner.
Yeah. And then you have things like reasonable security.
Yeah.
What is reasonable? We're still trying to figure that out. But I think, what I have seen is I know that Kamala Harris, when she was state attorney general, had published a document, and she's been very active in terms of cybersecurity. And so I think we have some frameworks that we could point to. While it's not directly mentioned, I don't think in the CCPA. No. Fotis or Devika, any thoughts on that?
I think my thought is, I think this is the crux of the problem, that most of these frameworks, they have a high level language that can be interpreted, dually about what is secure, what is not. So when you go into the cybersecurity assessment from an IT standpoint, you have to be precise, and I've got an engineering background. So when you say secure, do you mean 128 bits? Do you mean 256? Do you mean a symmetric and asymmetric encryption, right? And then none of these regulations, and I know we'll talk about Schrems, points that out, even ISO, and then, NIST, they're all high level frameworks. So that's why, like Devika said, I can't agree more than you have litigation left to right, because, those aspects from a pure technology standpoint are not clarified. So when you go to the cybersecurity assessments, you have to be very careful, and also careful sometimes when the auditors see that, to make sure that technically, because even in Schrems and GDPR, it says like what is technically safe and the best encrypted algorithm, but it never tells you what kind of algorithms are the one that they pass muster and what are not. So I do have that issue with my clients as well.
Yeah, and I'll say that, we had that same problem even before CCPA with Section 5 of the FTC Act, right? Where it was, you're supposed to have the reasonable security measures, and one of the head enforcers at the FTC was asked that at a conference that I was at, hey, so what does this mean? And he's like, it's clear. Look at our consent decree. And he was straight face said it. It's clear, look at our consent decrees. And so that's the advice that was given. And we actually keep a running memo now. We need to update it, but we keep a running memo of what was bad. So Fotis, to your point, right? We know what it's not. And so we try to kind of live by that. Like, don't do this. And then maybe you have a good chance of having your assessment be what it needs to be from a cybersecurity perspective.
All right. So to keep things interesting, we now have CPRA. And I'm really hoping that we land on one acronym. And I think it'll end up being CCPA, but I don't know. We'll wait and see. Because I think, the CPRA, which was the ballot initiative that passed in November, Prop 24, really amended the CCPA and brought it more in line with a lot of the requirements under the GDPR. So here's a great side-by-side comparison, shows you kind of where CPRA comes into play. And, there's a lot to talk about here, but a couple of key things that I'd like to highlight is that it will require companies to get serious about adopting data retention requirements. So there's a limit on how long you can keep information. Now, it doesn't tell you how long to keep personal data, right? Because it's based on the context. Why do you have this personal data? What's the business process that it supports? But it's clear that if you over retain records or information that contain personal data, it's going to be viewed as negligent. So that's one thing to highlight, and we'll touch on that today. I think a big one here is the right to correct data. That is brand new. That comes similar to the GDPR, that consumers can ask you to correct their data. So that's a big one to think about. Establishing a dedicated enforcement agency. And another one here, cybersecurity audits, just to name a few. So Devika, anything that you'd like to sort of highlight here for our audience today?
Sure. Yes. And I think what you've highlighted, I agree, like the most interesting part of this chart is what you've highlighted. I just wanted to cover a few things that aren't on the chart. So folks, because people are like, boo CPRA, and I get it. And there's even another acronym, CPPA, the Consumer Privacy Protection Agency. I'm like, come on, guys. But one of the things that was not on here that is, I'm going to say maybe helpful, is there's now this, there's a little bit of clarity on cross-contextual, cross-context advertising, behavior advertising, right? So this idea of sharing, when you guys hear it, when you hear CPRA and there's this word sharing, it's a very narrowly defined term. And I'm not saying CPRA is not scary, it is. But I do want to maybe bring people's blood pressure down a bit. And when it talks about sharing, it really is talking about that type of sharing. Where it's sharing with another for the purposes of this cross-context behavior advertising or some very specific categories. So when you're seeing that in this list, that's what it's talking about by limiting sharing. It also is going to expand for any, ACC has all types, not just big companies. So those who are maybe legal counsel for smaller organizations, they're actually raising the threshold and getting rid of devices when it comes to who it actually applies to. So it's possible that CCPA could apply to an organization, and then CPRA, it will not apply. So the CCPA will no longer apply because the organization didn't have 25 million in revenue, didn't derive its revenue from sharing, and doesn't collect over 100,000 pieces of information, or information from 100,000 consumers or households. So I just wanted to highlight that, Rebecca, in addition, because I think this is a great chart and it's available online. I highly recommend it. I refer to it all the time because it's the GDPR comparison. That's a great one done by the organization Californians for Consumer Privacy, who came up with all of this.
Mm-hmm. Yeah, and I think, this concept of high risk data processing, you have to perform, more thorough audits of those. FOTUS, again, cybersecurity. You can't have data privacy without security. Can you talk a little bit about that?
Yeah, sure. I think one of and I love this chart because you can find charts like that easily comparing the three frameworks that they're, cousins, they're pretty related to each other. I think so now with the CCPA 2.0, what happens is there's that, California agency now that audits, and then just like GDPR, you need to provide that cybersecurity assessment on a frequent basis. So in GDPR, it's called DTIA, like the Data Transfer Impact Assessment. So now that translates from the European Union into California. The funny thing is consultants like me have, more work now because you have to audit those organizations. And like Devika said, I think I love the way she put it with a company in Houston. We do see companies like I had an international bank that they based in Taiwan. They had like two customers based in California. They still fall under CCPA. I know, the 2.0 version, they doubled the number of customers. So now maybe some SMB clients that won't be affected, but they're still under the umbrella of the 1.0 version.
Yeah, it does have quite a reach for sure.
One thing I'll underscore too, in that is kind of highlighting this chart, Rebecca, is CCPA and CPRA apply to the business, right? Like it is, a business is a covered business. We're going to talk about this next, I know, but with GDPR, as we start talking about it, I always remind people it's talking about whether or not the data is subject to GDPR, not necessarily your business, because most of the folks on this call or on this conference are not necessarily, well, you're here, so you're not located in Europe. So it's not that you're a covered business, is that data that you're processing is covered by GDPR. Whereas CCPA and CPRA, it's like you're a covered business, all this applies.
Yeah, that's an interesting point. And I think this some of these requirements, really compel companies. If they didn't do a really good job preparing for CCPA, guess what? They're going to have to really get serious now. We'll talk about what some of that means here in a little bit. And just like California with data breach laws, they're leading the charge here. I know we have some other states that have enacted similar regulations, not quite as robust as CCPA or CPRA, Nevada being one of those, very limited. But we're already seeing other states. We saw a little bit of a flurry, I think, in early 2020, end of 2019, a lot of copycat CCPA type laws or legislation being proposed. We're seeing that pick up again. I think due to COVID, things really slowed down, but we're already seeing some more activity. Davika, can you talk a little bit about some things that you're seeing, some trends?
Yeah, and one of the trends, you got it highlighted here, which is, this is a great chart that Exterro has. I highly recommend kind of checking in on it. But you see these committees, like that's one of the trends, right? You got the in committee means in committee, like with the Senate or the House, but the ones I'm talking about, the green, these task force, and then even Washington with this cross committee, that's really basically kind of like a task force, because Washington, if you don't know, has tried and tried and tried to pass a version of CCPA and has failed, because it actually tries to take CCPA one step further and be even more aggressive, and doesn't have some of the cure periods that CCPA allows for violations before the AG enforces. So that's part of the controversy. But one of the trends is folks are really just starting to study it. They're realizing maybe we can't get a bill all the way through, but we can study it. And so they're having folks make recommendations and having privacy professionals make recommendations, which I hope makes for better law as a privacy professional than just having, no offense to California, but having a ballot initiative be how it happens. We haven't really seen a ballot initiative anywhere else, Rebecca. You guys follow a little bit closer, but I haven't seen it in what I follow. But I have seen a lot of these task force, and I've also seen a pushback on the private right of action that has stalled out some of these bills. When they try to make a more expansive private right of action, one side of the House says we're not doing that, and that kind of stalls the bill out.
Yeah, we've sort of seen that private right of action play out quite a bit in Illinois' Biometric Information Privacy Act. Yeah, a lot of litigation around that for sure. And FOTUS, Davika, you mentioned New York Shield, we got the New York DFS, some more targeted within an industry. FOTUS, can you talk just real briefly about some of those requirements?
Sure, yeah. So I think some of our clients being on financial services, they're under, generally there's that, Graham Leeds Bliley Act, the GLBA, that they fall under regardless of state. So that talks about sensitive information or personally identifiable information. Now, it's not as restrictive as GDPR and other frameworks, but it's pretty strict when it comes down to protecting your banking customers' data. And then New York tried to mirror CCPA for the banking industry, for financial services. And they came up, the New York Department of Financial Services, they've got the NYDFS 500. You can also find it as Article 23. And funny enough, from all the frameworks we mentioned from a technical standpoint, it's a little bit more well-defined, meaning it does mention, and especially with COVID, they came up with additional provisions around bring your own device, about multi-factor authentication, about organizational data management and governance. And they also talk about encryption as well. So this is something that we serve our clients, and we've seen a lot of movement around NYDFS. Also, it does enforce the good thing from an organizational standpoint. NYDFS 500, it does enforce a bank, and it can be an international bank that has a branch in New York. They do need to have a CISO, a chief security officer. We did find instances that huge banks, international banks, but they had small presence in New York. They haven't had the organizational hierarchy to provide a CISO locally. So they had a global chief security officer, let's say in Taiwan or Japan, but not somebody in New York. So that's something that the auditors will pick up on. You need to make sure you've got the right folks locally. How you store the data. So the data needs to be stored obviously in New York. If it's stored overseas, then there's another red flag. And also when it comes down to the SHIELD Act, that obviously covers all the businesses, not only New York, not only, financial services. However, with the Shield Act, if you're NYDFS compliant or in healthcare HIPAA compliant, so if you compliant or with other legal frameworks, you don't need to do Shield, just like GLBA. So we found instances that NYDFS is sort of like a stricter framework, goes what Devika said. So organizations, banks would pay more to be NYDFS 500 compliant, and by default, they were compliant for the Shield Act.
A lot to think about, definitely. All right. So let's move a little bit more globally here into the Schrems 2 case. A lot of guidance coming out, not so helpful in some cases. But before we dive into this, I think we have a two-part poll. So if we could bring up the first one. All right, so if everyone could kind of read through this. First, we just want to know, how familiar are you with the Schrems 2 decision? And the second part, if you are impacted by the Schrems 2 decision and Privacy Shield being invalidated, where are you in making changes in response to this decision? All right, so I've heard about it. That's why you attend these CLEs, so you can learn a little bit more. So we're going to dive in, and it looks like folks are still sort of early stages or still thinking. So sounds like there's some work to be done. All right, I'm going to go ahead and close the poll here. All right, Devika, is that surprising, or is that kind of what you expected?
I mean, it's what I expected, but it's really helpful to hear, because Rebecca and Fotis and I were speaking, and we're like, well, we don't want to like cover a bunch of stuff on Schrems 2, and people are like, I know it, I read about it in my sleep. So it's good to hear that folks at least have heard about it, so you know what Schrems 2 is in principle, and then also that still thinking in early stages. For those that are almost there, I'm like, kudos to you, because I can tell you, you know, we have clients that we're still who are Privacy Shield certified, who are still trying to figure out if SECs are going to work, especially with the new SECs on the horizon, right? Like, should we really go through all this work to start contacting vendors and get those in place when new ones are coming? So the still thinking I get, because there's still, it's still in motion. So for those who haven't spent hours analyzing it, I'll say the crux of the matter for Schrems 2 is that the US EU Privacy Shield, EU US, because unlike the safe harbor, EU came first this time, but the EU US Privacy Shield was invalidated, which meant that a lot of organizations who really relied on this self-certification process with the government as the way to transfer things out of Europe, the personal data out of Europe to the US, now don't have a legal mechanism for transfer under Article 46 of GDPR. And so, right, people are in disarray. And in this case, for those who haven't spent hours analyzing, it did have a question about the SECs in it too. So there was actually two cases that ended up combined that Schrems had kind of started against Facebook. And both of them were looked at by the Irish Data Protection Authority. And ultimately, the opinion, though we focused on the invalidation, it did say the SECs as they stand are okay, meaning for now. Right, like because new ones are coming. So that was, I guess, good news from Schrems 2 that folks you could take away from it. I think as far as what else to know about it is this guidance has come afterward, Rebecca. You know, without spending too much more time going in the case itself, the guidance afterwards is what's got people going, wait, what? Because if you have there's this whole tree which Rebecca will send. Exterro has kind of taken taken it off of the EDPB site for you guys, is a guideline on how to do this, like step by step. And it sounds easy when people say step by step, right? 1, 2, 3, 4, 5, 6, you can do this. But the steps are know your data, which we'll talk about, right? Know where your data is. The second one then is, okay, and then determine how you're gonna transfer it, okay? But then is where it gets thorny, because it's like, well, if you're gonna transfer it through BCR, because the adequate decision, you're good. Keep going, adequate decision stays. But if it's anything else, BCR, certifications, and BCR binding corporate rules, SEC, the standard contractual clauses, then you have to do this next step and determine, does that in and of itself, even though SECs were confirmed, you still have to do the step of, but are the protections in that country actually adequate? Which is interesting to me because, yeah, and I skipped ahead, sorry, Rebecca, to what
You're good.
Okay, what's interesting is, when you don't have any of those other things under Article 46, if you don't have SECs, BCR certifications, or adequacy decision, the requirement is to determine there's an adequate level of protection in the destination country. So wait, what? So basically I did all these things you said were okay, but I still have to do the step that I would have to do if I didn't have any of those other things in place. And so practically what that's meaning is you've got to actually do some due diligence. You can't just do from like a contract lawyer's perspective, you can't just throw SECs out there anymore. You've got to have some paper trail, and this is where FOTUS may come in, that you have kicked the tires on how the cybersecurity is, that you have at least asked some vendor questions, that you have determined that what government access is going to be given to that data that's on your system. So I'll stop there to say, FOTUS, I know that you kind of dealt with this a little bit. What have you been seeing as far as these supplementary measures that folks are having to put in place if they have a gap between the mechanism?
Yeah, I think that's a very good segue. Thank you so much, Davika. So like you said, SECs, it's a little bit of a gray area that are they enough or not? There is that, supplemental, there's some guidance as of November that was open to the public. And then I think they certified it and closed it on December 20th or 21st regarding, how do you want to do additionally? What do you need to do additionally to the SECs? And they came up with, just a couple of major areas from a guidance standpoint that, they need to be more practical, obviously, for my purposes. And one of them is technical guidance. So they do talk about the encryption, like end-to-end encryption, meaning the user will own the keys, and no pun intended, but the key is that the private keys for encryption they shouldn't be where the importer is. So if the exporter obviously will be in the European Union, the importer in the US, and things become more complicated when they're using cloud providers, when they encrypt the data while they're transporting them to the importer, you can give them the keys cannot reside there, so they can decrypt them. And the idea is, the government cannot come in and ask you to give me the data for X and Y, and then they're not protected. But at the same time, that, from a practical standpoint, if the data need to be used, for certain aspects, let's say for HR, personnel records and all that, how do you decrypt them? How do you get the data? So in many cases, what they say practically is find a cloud provider. And I'm here to provide more of a practical solution that, so they do say, find a provider that potentially like, Microsoft or, Amazon or Google, they have those cloud senders in the European Union. So you don't actually transport them, and the importer can basically log into that cloud. The problem is, and I think Davika touched upon it, there was a great point about it can become really expensive, because now you're paying somebody not based in the US, you're paying more for a cloud instance based in the European Union if you're a US business. So maybe business, Fortune 100 companies can cover that expense, but smaller companies cannot. And then, so that's a technical guidance. There is also organizational guidance regarding how the company needs to be tiered and the hierarchy behind it and the security guidelines. I can't stress enough the data governance, which even in big companies, you can find about who's accessing what. And in many cases, you've got many sources of truth. So you need to make sure, and I think Rebecca will touch upon it around data mapping and data inventory. You need to be really aware of that to map your data. And I see that a lot of places, especially when we talk about unstructured data, PDF, Word documents. In many cases, big companies throw them on the cloud in a construct that's called a data lake, and then it's not easy to understand what's going on from a cybersecurity standpoint. And then the last thing I'll say is, I want to delve peel another layer from a technical standpoint. They do talk in the supplement for the SSCs, they do talk about encrypted data, which are covered, but then you have pseudonymized data, which under GDPR, they consider to be personal data. That means you need to protect them. So you also need to be careful, and pseudonymized, I think it's a fancy word that means map data. So instead of using social security number, you just have a table and you say that corresponds to that static number. If somebody gets a hold of that table, basically they know their personal data. So, you need to be really careful from a cybersecurity assessment standpoint, how you delve into encryption and pseudonymization, and also the organization needs to be tiered the right way.
Yeah.
Well, and I think that Such a good illustration of why legal and IT really need to be working together on these issues, because you both have different perspectives, but there's so much overlap in the need to work together on these items.
Yeah, and Rebecca, thanks for putting this up. I mean, this is I spoke ahead of myself on this slide, but I think it's a good one. It's where we sit and we compare the two. So I was spitting a lot of acronyms. I tried to spell them out, but here they are spelled out. So I won't go over these, but I will say, look, pre-Schrems, the two things that we haven't talked about is there was express consent, and it still exists. So to be clear and to be a little solution oriented for those who are still thinking in early stages, express consent to the extent practicable, right? For those who are a B2C company, sometimes it's going to be hard to do from everybody, but maybe if you have a very small European presence, and that data set is very small, but express consent from the individual. And then also the binding and enforceable commitment to apply appropriate safeguards. We talk about SECs as if that's the only contract. Again, I'm a contract lawyer, so I try to remind people like SECs are great and they're a nice shortcut, and I like them because when I add them, then I know I'm good. Well, at least before Schrems, I know I'm good as far as the contractual protections I need to have between the parties. But really, if you had a data protection assessment, a data protection addendum or agreement that has basically what's required by Article 28 for your data processors, and you had things about transfers that ensure it's appropriate level of protection, you're still having a legal transfer under GDPR. So I like to remind people that SECs, though they feel magic, they're not the only solution contractually. What's different is what we just talked about, right? This post-Schrems. Now you got BCRs, which for those of you who don't know, binding corporate rules require, like it's really only for affiliates, right? You have affiliate in the US, affiliate in the EU, but you have to get them approved by the Data Protection Authority. So it's not a quick fix. It's not, for those who are still thinking in early stages, it's not something you're going to get next month or even next year. It usually takes a couple of years to get BCRs approved. But then even that, you still have to assess. So now people may think BCRs aren't really as valuable as they used to be because I still have to assess with FOTUS, and I still have to, the biggest thing is I have to suspend, and the guidance that come from EDPB is you have to immediately suspend or terminate if you find a gap. What hasn't been answered very well is how often are you supposed to be assessing? They suggest it's continual, but we all know, FOTUS can tell you, I don't think any of us can have managed security services that are continually monitoring all of this. Like, it's just not a thing. So you have to kind of decide how often you want to do that. But the big thing is that Privacy Shield went away. And that there was a question, Rebecca, I know in the thing, and I just wanted to address it because it kind of hits this, is some people say, well, I've got AWS, because FOTUS mentioned that. I got AWS, I'm good, which is partially true because AWS has taken a lot of efforts to get the right things in place, but know that ultimately you're responsible. If it's your data, yes, as a controller, even if AWS is managing the services and you don't own one server, know that all this, please don't zone out and start doing work while we're talking, because this still applies to you yes. As the data controller.
Yes, I think exactly right. I can vouch to what Devika said, and actually AWS, Azure, and GCP, the three cloud providers, they do mention that. Like you're the responsible party, like Devika said. Don't think like because they're hosting your data, and in some cases you don't even know where the actual servers reside because they virtualize them and they provide you the cloud, that if something happens, they'll be penalized. I think you're the one that's on the hook for that.
Yeah.
All right. Well, we've got sort of the second part of our presentation. I'm keeping an eye on the time. We are getting a little tight. I want to make sure we leave some time for questions at the end. So FOTUS and Devika, you guys did a great job of sort of outlining the complexities of the regulatory landscape, but also the need to have that strong foundation so that you can meet the existing, but also those emerging requirements, because things are going to change. I think that is a given. And so you both have talked a lot about knowing your data, having a data inventory, which really comes down to what do we have, where is it, who are we sharing it with, how long do we have to keep that information? If you don't have this solid foundation, it's going to be hard to address any of these components, from updating your policies and disclosures to bolstering your security practices. If you don't know what you have and where it is, who you're sharing it with, it's going to be really hard to protect it. Another key component we talked about under CPRA, and it's already part of GDPR and some of the other emerging regulation, is limits on retention. So companies have to get serious about applying and adopting retention. And that doesn't mean just having a retention schedule, check. It means you're actually putting that into play, that you can demonstrate that you're actually getting rid of information. And the data inventory is really the key to operationalizing your retention obligations. And I'll show you what that looks like. We didn't even talk about this. We could have spent a whole nother hour just on streamlining consumer requests, but you have to know where your data is if you're going to be able to respond in a timely manner. And we talked a lot about third parties. The data inventory, while it starts internally and looking at what data you have in your organization, it extends to those third parties. We talked a lot about assessing those third parties. So you got to know what data those third parties have, how they are protecting that information. Do those retention obligations extend to those third parties? Are those third parties going to have to help you with those consumer requests? A lot to think about. But if you have that solid foundation of that data inventory, it's really going to make your jobs a lot easier. And what I like to tell in-house counsel, because I think when you say data inventory and data map, it sounds really hard, right? I think that's sort of, it's, not everyone, this is their full-time job, right? So it can seem really difficult to do this well, but it doesn't have to be. We've been helping companies do this for over 15 years. We actually pioneered data inventorying and data mapping back when the federal rules of civil procedure changed, and then privacy sort of came onto the scene. So we've been doing this a long time. I like visuals. So this is just a nice depiction of, what would you want to make sure is included in your data inventory, whether we're talking consumer data or we're talking employment data, it's all contains personal data of the organization. So this is a nice visual depiction. As we mentioned, it's something that has to be kept up to date. A couple things I'll point out here, understanding, the data subjects, really documenting the personal data elements, how you're getting that information. And don't forget, people, your departments, how they're interacting. I was on another webcast yesterday, and they were talking about HR data. Guess what? It doesn't just sit in HR. It's all over the organization. So knowing how your departments are interacting, knowing those applications, I think when companies take sort of a myopic view and say, hey, we're only going to look in applications because that's where our personal data is, they're really missing the bigger picture on where else that exists within the organization and outside. Data retention, we'll touch on that as well. So this is just a nice visual, but let me sort of break it down. And these are real reports that come out of the results that we work with clients. I think it helps illustrate again how legal and IT can work together. So this business process is HR onboarding. We've documented the purpose. We've documented all the various personal data elements that it contains, who it pertains to. And then page 2 starts to layer in some of those key things like those third parties, those transfers. Where is this going? How are we sharing it? What are the applications? And then looking at retention. Again, while data privacy regulations require retention, it does not outline how long you need to keep it because it's really based on the context. Hey, are these benefit records? Are these customer service records? Are these warranty records? What sort of personal data is associated? And that's how you bring all of these key pieces together. One of the cool things that we're able to do is look at how long are you currently keeping this permanently and compare that to what the regulations say. And what we have found when we've done these initial data inventories is that about 75% of record types that contain personal data are kept longer than the regulatory requirements. So really something to think about. That's a high number. The good news is you don't have to boil the whole ocean, right? You can really begin to focus in on your areas of greatest risk. So I know I'm moving quickly here. Fotis or Devika, any thoughts on that so far and how that can help from a legal or IT perspective?
Yeah, I just say legally, you mentioned, right, how long you should keep it. I mean, data minimization is still key, which I know you'll talk about, but that's when you saw those retention and it's like permanent, it's like, cause it's easy, right? It's permanent because it's easy. Not the word, think about it. And then you saw the legal requirements. I always say the real legal requirement is yes, whatever OSHA or whoever requires you to keep it, but also only as long as you need it. So if there's not a statute for it, I always advise clients only as long as you know. Well, how long is that? Well, think it through. It's like, but I want to keep this consumer record for 4 years because what if they want to come back and I want to make sure that we keep their preferences. I'm like, yeah, but they haven't interacted with you with 2 years. Then it's probably time to go and let them go. And that's a better practice too, because to your point of this over retention. So data minimization actually helps you from a litigation perspective later.
Yeah, the FTC has a saying that I love, and that is data you don't have to protect it. You don't have to produce it, and it can't be breached. So, and the data inventory really is the key to unlocking how do we begin to apply this, because legal wants to get comfortable approving it. IT, you're going to need their help enforcing it, and the business people. So all of those components really have to come together. All right. I just want to keep us moving here. Talk about third parties a little bit more. It was such, a critical component, I think, of CPRA. There's more restrictions around assessing and understanding your third parties, and also under Schrems too. So I think these questions are key. In-house legal teams, along with IT, really need to be able to answer these before something happens, right? Before a third party has an incident or a breach. So who are our vendors? Which ones touch our data? Knowing and documenting the specific data that they touch so that you can evaluate which ones are relevant to these various regulations. And then how are they protecting that information? I think those are 5 good questions. If you can't confidently answer those, and guess what? Sometimes it's, you can't answer number 1. I don't even know who all our vendors are. So again, I really like graphics because I think it sort of breaks down how you should be thinking about this. And it really starts with who is the universe of your third parties. Again, having that data inventory, what we always find is our clients begin to uncover third parties that they weren't even aware of. And these are service providers. They can be IT, marketing. It really runs the gamut, right? But the goal is to put them through what we call a vendor risk profile. And just a little plug here, we actually work with the Association of Corporate Counsel. They co-brand our solution, the ACC Vendor Risk Service, that can really help you analyze and understand your third parties and begin to put them in the right buckets to know which ones touch our data, which ones have access to our systems, and which ones do we not really have to worry about. This is going to enable legal and IT to ensure that they're conducting that appropriate level of diligence on those third parties. And it's not a one and done, right? You're writing into those contracts, those standard contractual clauses, that you have the right to go back in and assess. So if you're not going back and assessing, that's problematic, right? Because relationships change. The type of data that you may be accessing or processing or storing for that third party may change. And so it's really going to help to identify risks. It's going to surface those risks so that legal and IT can address those. So this is sort of the visual depiction, but what does that look like, right, in practice? You know, what is that sort of document that legal and IT can leverage to really understand and evaluate these vendors? And so this is an example here of a third party. You can see it documents what those personal data elements are, access levels, different security controls. We have some heat mapping over here to really help surface and focus in on the areas of greatest risk, right? So that you can really begin to see, hey, maybe they're not doing enough training around certain areas, or maybe they don't have this sort of policy or document in place that needs to be addressed. So I want to pause there. Fotis, and kind of from your perspective on these third parties, is there anything that you would highlight for our audience today when looking at this?
Yeah, I think I'll say 2 things for under that umbrella of, you know, the risk management from the vendor, the third party. So one is, let's not forget in CPRA, there is another category of PII data, which are called sensitive. So there is a more sensitive data that potentially your vendors may have access. So you need to understand, and obviously that's part of the software, and Exterro does a great job flagging that data. So you need to understand the difference between the two. And secondly is the idea of sub-processors like GDPR calls, or it's the fourth parties, for example. So you may not know, but your vendor, and it may be part of your contract, many times it may not, they're using fourth parties, subcontractors from their point of view for storing that data. So you need to understand where that data you have, who is actually storing them, and also they may be using subcontractors to access that data over, let's say, a mechanism to access them is over APIs. So it's either going to be part of your contract and also part of your IT cybersecurity assessment to understand risk behind it. And without going into the nuances, I know Devika is far more qualified than me. There is another thing about sensitive data when it comes down to not only social security and date of birth and the use one, but also IP addresses. Dynamic IP address is a major thing that I see in my clients. Is it protected or not? My vendor have access, but I do change my address every time they connect to my system. So there's also nuances that they need to be part of the risk assessment as well.
Devika, anything that you'd like to highlight here?
Well, just to underscore the whole point about the data subject access request, I think a tool like this, and I do want to tell people, if you do this manually, and I've helped folks do this manually where they have to, it's expensive because trying to figure all this out on the back end is way difficult. Like trying to figure out, well, wait a minute, we're supposed to delete this, but who else has it? That alone has caused some of my clients like having to ask for extensions from the data subject or tell them there's an extension, another 45-day extension under CCPA. So under CPRA, to your point, Photos, I just want to underscore that limit, that sensitive also includes things like driver's license number. Like these are things you would share normally, be like, oh, that's not super sensitive, it's not a social security number, but now you got this heightened responsibility.
All right. And one final slide, don't panic. Hopefully we gave you lots of things to think about, to be proactive and be prepared. But I think, going back to that foundation of having that data inventory, keeping it up to date, oversight of your third parties, it's really going to be the difference between being panicked and being prepared when something happens, when the regulator shows up. If your third party or you have an incident, it doesn't have to be the end of the world, right? If you can tell the right story and show that you have, these controls and this diligence in place, you can be in a defensible position. All right. So if you guys have any questions for myself, Fotis, or Devika, our emails are on screen. Please feel free to reach out to us. I've been keeping an eye on the chat and we haven't gotten a lot of questions. Let me just take a quick look here. Something about if the gameplay of a mobile app game collects loads of information about each player, but the gaming company is host. Okay, did we answer that one with the Amazon?
We did. Yeah, okay. That was the AWS one. Gotcha. I mean, I guess, Rebecca, since we have some minutes, I didn't want to put this in if we didn't have time, but I want to tell folks, like as in-house counsel, and I work with in-house counsel a lot, but also folks like Fotis, IT professionals, the best thing you can do as far as that be prepared so you can have that Zen state is really having everybody at the table at the beginning of product development. Because that's one of the things I do is help folks leverage tech. And when you've got everybody at the table, marketing, the IT developers, security, and legal, then you can do this thing called privacy by design. And it really makes your life so much easier. It takes a little more effort up front, but then everybody is invested the whole way. And it actually makes consumers nowadays kind of think it's cool, right? Like it's not a big deal to click, yeah, you can use my Bluetooth or whatever if you put it up there. But if your application developers are not even talking to your privacy people or your security people or your legal people, and then trying to put that in afterwards, that could totally annoy your consumer. So I just want to give a plug for privacy by design as part of your data governance, is start that at the beginning of every product development cycle. Yeah.
Otis, any final thoughts? We got 2 minutes here.
No, I think I can agree more with Devika. I was in the industry as well as a head of product. We always had all the people on the table. I know it's not a process that everybody enjoys, but it has to be done in the beginning because we had instances that we did it midway and that was really messy to provide those security guidelines. You need to have everybody on the table as part of the PDLC cycle and have your project management organization, PMO, responsible for it and make sure it's part of your PM plan.
And then one more scary thought, because we've got 2 minutes. And my partner, Jessica, would love that I'm going to scare you guys right quick, is do know that from the data privacy, but also the cybersecurity perspective, there is now the Uber case, if you haven't followed it, there's a chance of criminal charges if you as in-house counsel don't report things or do things a certain way, in a compliant way. And so I only say that to say, this is important. I'm glad you guys are attending it, because it's not just, oh, it's IT's problem, but it really is now, even from a executive and a in-house counsel, it's your problem about what happens with the data breach and what happens with data governance. So it's our problem now, not just our IT department's problem or our board's problem.
I think that's such a great point, Davika, and I couldn't have said that, ended on a better note, because oftentimes, because when something happens, when it hits the fan, it's going to land on legal's desk, and that's the team that's going to have to respond and know how to respond. So
the last thing I'll say to that point, in many of my clients, the chief security officer falls under the legal group, under the GC, not under the CIO group. So have that in mind as well.
Yep, that's a great point. All right. Well, Paula, I think we're wrapping up. So if we'll turn it back over to you, or Carrie, if we're going to do the drawing. I'm not sure if we can do that now. Are you ready to?
Absolutely. So thank you very much to Exterro and to our panelists.